Now I invite the members of the Grand Chamber who so wish to put questions to the parties, starting with Judge Yüksel, please.
Thank you, Mr. President. I have one factual question for the applicant. The other party government can, of course, also comment if they wish so. Before the domestic courts, the applicant stated that, and I quote, "I have not taken on any responsibility as a BBTM within the organization or anywhere else, and I've never used a code name contrary to the allegations of the witnesses." On the same line, before the appeal court and the Court of Cassation, he argued, and I quote, "The witness assertion that the accused is the principal regional coordinator BBTM is unfounded accusation and lacks any evidentiary basis." Then before the chamber, in his observations, the applicant, without providing an explanation regarding the use of code name or his role as BBTM, submitted that, here I also quote, "The applicant admitted having been accommodated in the organization house. However, he denied having performed high-level activities such as house imam, district imam, regional imam, provincial, etc." Then in his written observations to the Grand Chamber, the applicant accepted that the evaluation made by the Grand Chamber must take into account the factual basis as decided by the domestic courts. And the applicant then proceeds to give explanations regarding the activities attributed to him, in particular the use of code name and his function as a BBTM, specifying that, I quote, "All these functions were executed on a voluntary basis while he was completing his own undergrad studies." So my question is the following. How would you explain these differing positions taken over the course of the proceedings domestically and then before this court? Thank you.
Thank you very much. Followed by Judge Ni Raifeartaigh, please.
Thank you, President, and thank you to the various contributors so far. I have a number of questions for both sides. Unfortunately, they number 6 at this point on each side, but they cover much of the same territory, and it may be of some comfort to know that it may prevent other judges having to ask many questions. It may also be possible to provide you with a written version of at least the essence of these questions at the conclusion of this. So, to the applicant, first of all, and may I preface this by saying a lot has been said about the wider context, and while, of course, that is important, we need to focus on the particular case in hand, and these questions are directed at events in this case primarily. The first question to the applicant is, do you accept that you did not raise Article 30 of the Criminal Code expressly or in substance in the domestic courts? Question 2. Before the trial court, the assize court, your position was that the witnesses were lying and that you had very little connection with the organisation other than minimal connections. Your arguments now to the Grand Chamber might be considered to implicitly accept that you were a BBTM within the organisation. Should the Grand Chamber now proceed on the basis that you were a BBTM, or is this fact still disputed? Similarly, do you still dispute that you used a code name? If you do dispute it, what is the relevance of the evidence you submitted in relation to the use of code names in Turkish religious organisations, if your position is that you did not use one anyway? 3, do you accept that you did not raise the issue of foreseeability or mens rea specifically in the domestic courts? 4, in your observations you make many arguments. One of them is that the characterization of the organisation FETÖ PDY as a terrorist organisation always was and continues to be incorrect, mistaken, wrong. Why are you making this case when your defence in the domestic courts was that there was little or no link between you and the organisation? Why today are we hearing so much about the Gulen movement generally and all the other cases not involving you? 5, can you explain where you get your figures from in relation to the numbers of BBTMs in Turkey? Finally, arising from the oral hearing today, 6, do you accept that in Turkish procedural or evidential law, witness statements taken by the police and on the case file are evidence, even if the witness did not give oral evidence to any court? I'll repeat that. Do you accept that witness statements taken during the investigation, which are on the case file before the court, but where the witness did not give evidence to any court, constitute evidence? And similarly, in Turkish law, do you say that documents which come in after the conviction but are before the appeal court can be taken into account by the appeal court? So there's considerable overlap to the government. Questions 1 to 6 are 1, regarding Article 30 of the Criminal Code, does an accused person have to expressly invoke it, or is it sufficient if it's raised in substance? 2, Article 30, which is the mistake provision in the Criminal Code, appears to require an accused person in the context of a membership case to show that he did not have knowledge of the violent or potentially violent nature of the organisation. How does this work in practical terms? I will confess that I spent much of my life at trials in criminal courts, so I'd like to know how this works in practical terms. What kind of evidence is used? And in particular, does an accused always have to give evidence himself about his lack of knowledge for Article 30 to come into play? 3, what is the relationship legally between Article 30 and the Court of Cassation 7 layers approach as described in their judgment of 26 September 2017? The Court of Cassation said the upper layers must be taken to have knowledge of the true nature of the organisation. Does that mean that Article 30 simply does not apply to those upper layers? 4, in that context, can you please confirm what layer specifically the position of BBTM is said to fall on? 5, concerning the number of BBTMs in Turkey, in your written observations, you comment that the figure given by the applicant, repeated today 150,000, does not come from a reliable source. Is that all you wish to say about this figure? And finally, 6, the same question about witness statements. Can you confirm that witness statements which were taken during the investigation but where the witness did not give oral evidence are treated as evidence by the court? And what is the status if documents, witness statements, HTS reports come in after the conviction but before the appeal is concluded? Can that be taken into account by the appeal court? That's a procedural question as to the evidential status of the documents. Thank you. And thank you, President, for the patience of all the court.
Thank you very much. Judge Ni Raifeartaigh, followed by Judge Guillaumard.
Merci, monsieur. J'ai une question. We can hear me now. Thank you very much. I would have a question that I would like to address to the representatives of the government, but of course the representatives of the applicant are free to answer that question if they wish to do so. You have indicated in your pleadings before the court this morning the elements that are constitutive of a criminal offence that is provided for in Article 314 of the Code, and you've mentioned the criteria of continuity, diversity, and intensity. And then, if I understood you correctly, you made a distinction between this criminal offence that I have just described and possible legal acts that could be attributable to an individual, the perpetration of which, if I've understood correctly, if taken as a whole in a certain context, could make it possible to characterize the criminal offence. Here comes my question. With regards to the 8 different acts imputable to the applicants, if I'm not mistaken, what is your position with regards to each and every one of these acts? Are they all lawful, legal in and of themselves? Are some of them illegal? And if so, on which basis are they deemed to be illegal? And supposing that each or every one of these acts attributable to the applicant and which serve to qualify the criminal offence of Article 314, and I refer you to the Yashinkaya judgment, paragraphs 253 and 254 and 270 and 271 paragraphs of the judgment, how you do reconcile that with the demand of foreseeability to which is attached the absence of objective responsibility. You need to individually characterize the moral element of an offence for that to be established. Many thanks to Judge Guillaumard. We'll listen to President of Section Judge Tsitakis.
I have one question for both parties under the claim of Article 3. I want to know what is the position of the parties about the duration of the detention in Unit F5 of the applicant, and if he was forced to sleep on a mattress on the floor, and for how long. And my last point on the same claim, about the same claim, is if during his detention in this Unit F5, he was forced to sleep in the unit communal living area in which the light was always on during the whole detention of the applicant. Thank you.
Thank you very much, Section President Pistakis. Now I turn to Vice President Jelic. It does not appear to be working. Are there any microphones that are turned in apart from mine? No. It appears that we have a technical issue. The microphone of Section President Pistakis cannot be turned off. Is there...
Okay, so I hope now it's working.
Yes.
Yeah? Okay. Vice President Jelic, please.
Can you just turn it off?
Sure, I'm trying.
Now, I think your microphone is on.
Okay, so my mic is on now. I would like to thank to both parties for their contributions. I have two questions for both parties, and I would appreciate it, the applicant and government reply to those questions. So my first question relates to the intent requirement of the offence of membership of an armed terrorist organization. National courts appear to have established this element in the applicant's case based on evidence including his position in the organization, the payment of his social security contributions by a company, affiliated with the organization, his contact with members of the organization, and payment he made to a bank affiliated with the organization in a certain period. Can you please clarify, first, the legality of the activities engaged in by the applicant, and second, whether it can be considered foreseeable for participation in legal activities to establish intent for a criminal offense? My second question relates to the reputation of the organization concerned at the time of the applicant's involvement. I insist on the time of his involvement. It appears that the applicant engaged in organizational activities between 2010 and 2014, well before the attempted coup d'etat of July 15, 2016, and before the organization had been classified as an armed terrorist organization by domestic courts. It should also be noted that the organization concerned had a reputation for many years before as a religious group supported by a significant part of the population in Turkey. The court has not been presented with direct evidence that the applicant knew of the organization's violent objectives at the time of his involvement. Under these circumstances, how could the applicant reasonably be considered to have knowingly and willingly participated in the activities of a terrorist organization by his acts that took place before the organization's true nature was known? Thank you.
Thank you very much, Vice President Jelic. Judge Felici. Again, we have a technical problem.
Okay, now I think it's work.
Okay,
okay,
it appears to be working now. We apologize for any inconvenience in this respect. Please, Judge Felici.
My question followed the one made by Judge Kikakis. Once you have clarified this factual situation, I'm talking about the claim under Article 3, could you please elaborate about the reaching or not of the threshold required by the same article for degrading and inhuman treatments? I will be more precise. I only ask the applicant to reply on the submission made by the government in the written observation 24 February 2015, according to which the elements put forward as to have to lead to a finding of no violation, and vice versa. I ask the government, please, to elaborate specifically, to reply about this written submission of the applicant, according to which there is room for a finding of violation. Just precise on these 2 points as a reply. Thank you so much.
Thank you so much, Judge Felici, followed by Judge Seibert-Fohr.
Thank you very much, Mr. President. And my question is turned to both parties. I would like to turn to the difference between the actus reus and the mens rea. The government's counsel, as also stipulated by Section President Guillaume, has stated that there is a need to distinguish between the crime and the acts attributed to a person in order to prove the crime. Now, my question is, to what extent can the acts which are considered to be constituted of an actus reus at the same point of time be considered proof of the mens rea? I'm asking this question because I'm asking myself, in this particular case, was there a difference between the acts attributable to the applicant, which went beyond the actus reus, taking into account that a certain threshold is needed in order to prove the membership in a terrorist organization? And I would also like to know, how can this be reconciled with the court's jurisprudence in GIEM versus Italy, that the guilt concept requires a mental link according to Article 7. I would also like to stress that over here we are confronted with a crime where, as stipulated by both parties, there is no need to have any kind of violence being involved. So I was asking myself, to what extent is it necessary to pay particular kind of attention to the establishment of the mens rea in this context in order to show the previsibility? Thank you.
Thank you very much. Any further requests for questions? Yes, Judge Đurović, please. It appears that you have to wait. You push the button and you wait for some time and then it comes.
Yes, it works now. Thank you. Thank you, Mr. President.
Okay. Patience is important, apparently.
Yes, patience. I would have a question both to the government, to the applicant, in relation, again, continuation of the question in relation to Article 3, alleged allegation, regarding the conditions of detention in Çorum prison, especially in the context of the number of people being detained, and we were provided with some information in relation to the kind of supply, let's say, of hot water, cold water, and other necessary elements for daily life. So could you please tell us how this has been kind of addressed during the stay in prison of Mr. Yasak? Thank you.
Thank you very much, Judge Đurović. Any further requests for questions? Now, this does not appear to be the case apart from my side. I have a question for both parties. Namely, first, according to my understanding, the Turkish law requires that the following elements of the offense be established in cases such as the applicant's, namely, first, the existence of membership in a criminal organization with all its elements. Further, that this organization be engaged or plans to engage in terrorist activities, and that this organization be armed. And I stand to be corrected by any of the two parties if my understanding is incorrect. Now, insofar my understanding is correct, I wonder whether the mental element needs to encompass all these elements on the factual side. More precisely, whether both the cognitive and the volitive part of the direct intent of an individual needs to encompass all these factual elements of the offense. And then, if this further is correct, I wonder whether the direct intent, or the mens rea, however you want to call it, can be inferred or presumed on the basis of actus reus, or the factual elements of the offense only, or does it require any further establishment by the courts examining the charge? And in case it is inferred or presumed to some or full extent, does this then require the defendant in such a case to specifically invoke error in fact or in law in accordance with Article 30 of the Turkish Criminal Code? So this concludes my question and apparently also questions by the judges. Now the court will withdraw for 30 minutes. That is until 11:25. And then when we return, both parties will have an opportunity to briefly, but very briefly, comment on the pleadings of the other party and answer the questions of the judges. The hearing is thereby suspended.
La Cour.
Please be seated. The hearing is resumed. I call upon the representatives of the government to provide their brief observations to the pleadings of the applicant side and also to provide the answers to the questions put by judges. Please.
Thank you, Mr. President. I must say I haven't felt challenged like this since I did the Jessup Moot Court many years ago, so thank you very much for your challenging questions. We will not engage in a tit-for-tat of facts about this case. I think both sides have outlined the facts in their various pleadings. For us, the facts are clear and we maintain our position on the facts, so we will not respond. Thank you very much to Judge Raifeartaigh, who basically provided us very helpfully with a list of questions, which makes our life easier. So regarding Article 30, Article 30 only applies once the prosecution has proven the intent of the accused, because the burden of proof is, of course, on the state. Once that is done, then the defendant must invoke it. There is no automaticity about Article 30. It will depend upon the circumstances of the case, also on the content of the defense. In our case, Article 30 would have not made any sense because the accused denied any involvement with the organization and denied the
you, Mr. Thalmann. There appears again to be a technical issue, and we apologize for this. Now, several colleagues are signaling that they can't hear you very well because the microphone possibly is. Can you check again?
I have a red light.
Okay, if you have the red line, this means that you have a green light. So please continue.
Okay. Otherwise, I can also speak up. I can fill a lecture theatre, so I will fill this room as well. So with regard to Article 30, that is the government's answer to question 1. The burden of proof is on the accused that he did not know of the violent nature. Now, how do you do this in practice? There have been cases before the Turkish court, including the Court of Cassation, where people have been acquitted because they could show that they did not stay in any of the houses of the organization, did not have any position in the organization, did not engage in any organizational activity, had no contact to other members of the organization, did not have a Bank Asia account, did not use any secret means of communication. So when this was established, then that was sufficient for the Turkish courts to then hold that there was no knowledge. So it was also used for the mental element. With regard to Article 30 and the layers, let me say at the beginning, although the applicant seizes on decisions of 2016, 2017, seizes upon layers, if you look at the decision of the Çorum Assize Court in this case, there is nothing about layers. You should take the decision of the Çorum Assize Court on its own. And there is also no question of jurisprudence developing subsequently. I think this case has to be evaluated on the basis of that very decision which we put before you, so you can see on what grounds that was decided. If we hypothetically engage in the question to what layers Article 30 applies, then according to the jurisprudence of the Court of Cassation, it would only apply to the first 2 layers. Now again, we have no decision by any court on what layer the applicant would fit in. As I said, these are individualized decisions where the layer of a person is not just decided on a single act or single fact, but the courts basically form an overall opinion on the basis of the acts and facts before them. Now, the government would say that a BBTM and ILCI would be in level 3 or 4, but definitely not in level 1 or 2. But this, of course, is the government's assessment. It is not the assessment of a Turkish court, because this question did not arise in the applicant's case. With regard to the number of BBTMs, and I'm always astonished by my colleagues who suddenly make 150,000 people in Turkey BBTMs. Again, the government has no clear facts on the exact number of BBTMs. After all, this was a secretive organization. But what we can say on the basis of the facts, there were 5 BBTMs in Çorum province, and there are 81 provinces in Turkey. So we are nowhere near 150,000. We are probably more in the range of between 500 and 1,000. But again, the government has no figure to present to this court. acts, and the government would take the...
It appears to be okay. Please continue.
The government takes the position that all these acts, which we have listed in Annex 2 or in Document 2, which we submitted, all these 8 acts are as such lawful. But again, as I said before, we have to distinguish between the acts that are taken as evidence to prove the offense. The offense is not basically being a BBTM or being employed by a certain organization. The offense is membership of an armed terrorist organization. So the lawful or perhaps even unlawful acts are used to establish the offense of membership of an armed terrorist organization. But the acts used for that, the acts from which both the mental and the material element are inferred, may be lawful. And in this case, we have 8 lawful acts. With regard to the reference in the Yalchin-Kaya case, paragraphs 253 and 254, the government agrees with what is set out in these 2 paragraphs, and we take the position that it is a question of foreseeability. And for that reason, our presentation this morning solely focused on this question of foreseeability, whether it was foreseeable, not whether the organization had already been classified, because that was only done in 2016-17. But again, if I may say here, we always focus here on 2016. But of course, every legal case has a history. Every legal case has a journey. So if we look at the final instance judgment in 2016, there have been decisions in 2014, in 2015. There have been investigations that started in 2012. So only what we see is then the final decision. But that doesn't mean that there was no knowledge or that there weren't any decisions holding that FETÖ PDY is an armed terrorist organization. We have decisions from 2014 saying that FETÖ PDY is an armed terrorist organization. We just don't have a final decision by the Court of Cassation. That comes much later after going through all these instances. With regard to paragraphs 270-71, as I outlined before, the government disagrees with what is said in Yalchin-Kaya, that there is a specific intent requirement. There is no specific intent requirement under Turkish law. As I quoted the Court of Cassation, the intent, unqualified, neither specific nor direct, intent, it says, refers to the materialization of the elements in the legal description of the offense willfully and knowingly. So intent here is a shortcut for knowledge and will. There is no further requirement here. With regard to Judge Kitsakis' question about the duration of the detention in Unit F5, the government submits that the detention lasted for 13 months and 3 days. There is no record, at least no record available to the government, which would show how long the applicant slept or was forced to sleep on a mattress. What the government can say is that it is wrong to say that in the communal areas the lights are always on. The lights are off at bedtime also in the communal areas. With regard to the question of Vice President Jelic, I think I've already addressed that part when you asked about the legality of the activities. The government takes the position that the 8 different acts, that Social Security is paid, that you make payments into a bank account, are as such lawful acts. But again, as I said before, these acts are used by the courts, taking account of their diversity, continuity, and intensity to infer the material and mental elements. So, for example, if you are holding a certain position, if you are engaging in organizational activities, that helps the court to establish an organic relationship, or it helps the court to establish that the accused made a contribution to that organization, either in a moral or material way. And the same is true for certain acts like being in a certain position in that organization, that we can infer from a certain position that you have a certain knowledge that comes with that position. But of course, that is not seen on its own. These acts are taken together, and this is actually emphasized in the Çorum Assize Court's judgment 3 times, that the Çorum Assize Court evaluates the facts as a whole. They don't look at individual decisions, and each of you as judges will know that you are not just seizing on one act, but you are forming an overall picture of a case where many contributing factors finally lead you to your judgment. And the same happened here. With regard to the question about the reputation of the organization, again, I have addressed that before. Here we have, of course, to distinguish between the reputation of the organization in the general public and what the organization is like for the members who are privy to the objectives of that organization. And of course, this is not something special with regard to Turkey or FETÖ PDY. If we think about other terrorist organizations, say the IRA, ETA, the Red Army faction in Germany, before the first bomb exploded, many of these organizations were not known as terrorist organizations. But of course, the members that were planning and were instrumental in these subsequent acts, of course, knew very well long before the general public knew. And of course, as we have outlined in our written observation, because FETÖ PDI is a sui generis organization, basically that tried to basically take over the state by infiltrating the various institutions, including education, security, the police, and so forth. Of course, here we have the people involved in that, which have much earlier knowledge than the people who are actually part of the general public. But again, as I said before, even the applicant's parents warned him and said to him, get out of that organization after December 2013, as stated by the applicant in his submissions to the Chamber. I'm afraid, due to the time constraints, we do not have any direct response to Judge Felici's question, but we would be happy to provide you with a written answer if that is what you would like. With regard to the question of Judge Seibert-Fohr, of course, that is one of the perhaps puzzling elements in this case, that we have both the mens rea and the actus reus, but it's not true that the actus reus is used to prove the mens rea. Again, the actus reus here is membership of an armed terrorist organization. Again, we have to distinguish between the criminal offense and the acts that help the court to establish that criminal offense. And of course, we have seen that the various acts of the applicant have been used, taking into account their continuity, diversity, and intensity, to infer both the mental element and the material element. So they have been used for both, but of course, the court basically looked at all of these and then formed an overall opinion. With regard to the question concerning hot and cold water in the prison, the government submits that there is cold water 24/7, so 7 days a week, 24 hours, there is cold water, and there is 2 days a week hot water for 24 hours. With regard to the President's question, the elements have been set out in Annex 1, and you can see in Annex 1 what the mental element has to cover. The mental element must cover is knowledge of the illegal objectives and that the organization uses or intends to use force. Now, if you want to change the constitutional order in a country, if that is your objective, and you will not achieve that through the ballot box, there are not many other ways open to you than to use force to achieve your objective. And of course, as we have seen from the statements presented by the government, from the leader of the organization, there is an element of force in those statements involved. So the elements that are to be covered by the knowledge and will have been set out in our document number 1. And as I mentioned before, yes, the mens rea element is inferred. It is not presumed. There is a difference in criminal law, as you all know, between inference and presumption. And you can see that if you look at the decision of the Çorum court, but also of other Turkish decisions, these elements are inferred. They are not presumed. If something is inferred, does the applicant has to prove an error in fact or law? No, the applicant, as I said before, and the Turkish courts have acted on that, they have acquitted persons that could show that this inference was wrong, for example, because there was no organizational activity, no Bank Asia account, and none of the other acts that are present in our case. I hope I have done justice to all your questions. If not, I am very sorry about that, but we had only 30 minutes. With that, I thank you very much for your kind attention.
Thank you very much, Mr. Thalmann. And as for your request that you provide subsequently certain factual clarifications regarding the question of Judge Felici, you are entitled to do so in the deadline of 8 days. That information, of course, will be submitted also to the applicant side for any comments necessary. Okay? So now I turn to the applicant side to do their part.
Thank you. I will comment on the questions about Article 7, my colleague about Article 3. First, as a reply to the government's statements before, it was said that by the first intervenient that our client did not ask confrontation. We refer to the Annex 45, page 2 of the documents provided by the government. It is the interview of our client of 27 November 2017, where he says, the witness is lying and I'm prepared to confront him. And we refer also to the judgment where he repeats, I literally say, the witness is lying and I want to confront him. So we really, the government denies, but it happened. Secondly, to the question of Mrs. Raifeartaigh, I'm not sure that the name is correct, I'm sorry for that. I refer to Article 40 because number 40 of our observations, because I think there's some misunderstanding. What we say is that the new documents were not submitted to the judges before the appeal. They were submitted afterwards. And the proof of this, we went into the files, and that is what we describe in article number 40 of our observations. When the case came before the court, the Ministry of the Department of Human Rights asked, give us all the information of the file. And there came information from another file with 9 witnesses where also our client was mentioned. But these 9 witnesses' statements were never in the file. They were never in the file. And you can see that we refer in number 40 to Annex 5, where you see the letters of the Department of Human Rights asking and the prosecutor responding that they were not in the file, but they found Mr. Yasakh's name in another file that they did not continue, and they joined it to complete the file. But it was not in the file. I want to be very clear. The HTS, the second report about the communication has been added now for the hearing here, not for the second chamber. It was not in the second chamber file. That's what we have been saying. I also want to reply already, I will come back. In the beginning of his answer, our colleague from the government said, the burden of proof that he did not know lies on the defendant. That was been said. Actually, it says it all. I will come back on that. But that indeed is true. It is the defendant, this Mr. Yasak, who has to prove the impossible to be proven, that he did not know the aim of the organization. I would like to ask you, if someone is asking you, prove that you did not know something. It is extremely difficult. It is extremely difficult. How can you prove that? I will come back on that. First of all, why the position is different. Judge Yüksel and also Mrs. Raifeartaigh asked that. Because it's another procedure. We do not deny anything that Mr. Yasak has said. But we are here not in an appeal court. If I would start now to say what the court, the Çorum court decided, we do not agree on that, we do not agree on that, you would say, here, you're not in an appeal court. We have to take into account what the court of Çorum decided. And that's 5 elements. And on these 5 elements, we say, if you would take them for granted, which we don't do, but if you would take them for granted, it's not sufficient to have a conviction of member of armed terrorist organization. If we would do differently and say, Mr. Was not a BBTM, he had no code name, and this, you would immediately say, we are not in an appeal. And you would be right. We have to start from the basis which is the court decision, and as here pleading before your court, we cannot plead as if we were for the Turkish domestic court. And that's why we do that. We do not change anything that Mr. Yasak had says, but we need to take into account what has been said by the Çorum, and based on that, we say this does not give us. And that's why we have to give information. What does that mean, a BBTM? What does that mean, a code name? Otherwise, we, of course, can never claim that it was an unreasonable decision. Article 30 was asked in the Court of Cassation, number 2015, bar 2021-7, judgment of the Court of Cassation 21-10-2018, so from 2018, The Court of Cassation said, considering that the defendant may have acted under a mistake that could eliminate criminal responsibility, the application of Article 30 of the Turkish Criminal Code must be evaluated by the court ex officio. That's a decision of the Court of Cassation from October 2018. We gave the reference number, so the case number is 2015/2217. So that's the first. Did he need to invoke Article 30? No. However, in his deposition his interview to the police, he clearly stated, he was asked, and he said, I did not know the aim of the organization. That is the deposition he made before the police, and he repeated that, I think, before the court, but I could not confirm that. But anyhow, in his interview, which is part of the files, he said, I did not know the aim of the organization. If it is ex officio, and he said he did not know, why should he then, in his defense, where he said, I was not a member anyhow, why should he all the time insist on Article 30? That is his way of defending, he has the right to, and the court should have examined that clearly. I come back on this element of Article 30, and several judges, you will excuse me that I do not address you separately, have asked about that. There are 7 levels, says the Court of Cassation. The jurisprudence is that for the level 1 and 2, it can be reversed. But for the level 3 to 7, it cannot be reversed. This is somehow contradictory to Article 30. When the Court of Cassation constantly say it cannot be reversed the fact that you knew and that you wanted to contribute, when you're in the 3 to 7, how then can you use Article 30 in an efficient way? And we know it has been nearly never used. We know from a court decision, cassation, who has been given by the government in the follow-up of the Alsinkaya case for the Committee of Ministers, where a person of 16 years, I think, was given Article 30 because they said he could not know. That's one explication we once found with Article 30 in a person of 30 years, of 16 years, excuse me. And secondly, we have knowledge of one where a judge was in trial, and it is quite cynical. They said Article 30 we accept because after 2014 he was actively campaigning in the elections for judges on the side of the government candidates. I don't have it with me, I know it by heart, I can send it also, I can send this decision to you, where they take into account what he did afterwards in the campaign of the judges. But otherwise, Article 30 is nearly never used because it's clear. 3 to 7, it is automatically you know and you want. And I take notice of the fact that the government has to admit that the level has not been mentioned. We don't know. Rightly you said, we don't know. The government now thinks 3 or 4. Yeah. If you condemn someone, you should know, and you have a court decision of the Court of Cassation and the Constitutional Court who says 1 to 7, at least you should have objective criteria. One of the elements of criminal law is that it's objective what you do and for which you are condemned. So he's now condemned because a hierarchical position between 3 and 7, something like that, we don't know, perhaps 3 to 4. As such, this is quite a very extraordinary element to say.
Mr. Hermans, I'm so sorry to interrupt you just for a second. You have taken now half of the time that the government has taken, and you are still at the questions of Judge Ni Raifeartaigh. I know that you referred also to some other questions. I would still invite you to concentrate a little bit more to the point of the questions.
Yeah. Judge Guimard, who said, are they legal? The government responded. Mr. Jelic, Judge Legis said about 2010 to 2014, what the government says, you could know because of the judicial actions. We don't see that as an element of information. And from the NSC, which only occurred in 16 and later. I will close it because I want to respond to your question still. In the jurisprudence, the knowledge about terrorist organization, one element, because you said, do they have to know that they are armed? I think also in the jurisprudence of the court, the capacity of the organization to execute terrorism is an element. You cannot evaluate an organization as terrorist. You have the aims, but it must be reasonable that they can execute. When some lunatic says, I will overthrow the state, and two people go with him, it will not be an organization of terrorists because they cannot. And I think, but I have not, I didn't found it, I must excuse for that, but the capacity to do it, so having the arms, you have to know that they also can do it. If you have knowledge, no knowledge that they could do it, then one of the elements of knowledge is not fulfilled. And now I give my colleague for Article 3.
The President, members of the Court, I will now address the questions that were asked by Justice Xitakis, Drovic and Felici on Article 3 of the European Convention. So just to clarify it, our clients stayed first only in the F5 section, where he stayed for 14 months. Of these 14 months, he slept on the floor for 4 months. Then he managed to secure a bunk. He slept in a common area, which in L-type prisons is an area that has always, for security reasons, the light on. We just checked with the client, he confirmed the light was always on for these 4 months. And he stayed there in that area, or in a cell section eventually, with 37 till 47 inmates, while the capacity is normally 7 detainees. We have explained that in our submissions. Then he was moved to the F10 section, where he stayed for more than 3 years. There, he slept for 10 months on the floor before he managed to secure a bunk. So in total, he slept for 14 months on the floor before he managed to secure a bunk. And in the F10 section, it was the same system, but there they stayed with 27 till 42 detainees. And then, as to the question whether that would lead to an inhumane or degrading treatment, I think it's also important to take into account, we have developed a lot of arguments in our submissions, but the aggravating conditions in that regard. The fact that he had to sleep on the floor, the fact that the light was on, the fact that there was constant supervision, no privacy, the fact that they had 2 showers and 2 toilets for around 40 people, combined with water shortages, and the fact that they only had warm water for 2 hours, 2 times a week for all these 40 people, which means that in reality you have, we calculated it, maximum of 7 minutes a week to take a shower per person. And in general, that was often not even possible due to the water shortages. And that then combined with the fact that there was hardly any place, that's also in the concurring opinion of Judge Krensch before the second chamber, hardly any space to move, to sport, to do anything else but sitting in a prison cell. And most of the times, at least until July 2018, all sports, educational activities, etc., were not taking place, were cancelled due to this massive overcrowding of the Turkish prisons, due to the thousands of people that were put in prisons. And eventually and finally, but this is also a crucial element, there is a fact that there were very high temperatures during the day, around 30 degrees, no air conditioning, so many people in a very narrow space together, and it became very cold at night, 8-9 degrees, again in such barbaric or hard circumstances that is not something that would lead to humane treatment. And therefore we think that the two things combined, the minimal space as we developed in our submissions with these aggravating circumstances, that would lead to a violation of Article 3 of the Convention. in general, because we have now been citing a lot of numbers and also some facts and some news sources which we have not managed to include in our submissions, we would also like to submit a brief written note to bring these factual elements in response to the questions of your judges to your court and make it a bit easier in your deliberation. So we will also, if your president would allow us, follow the same time frame as the government. I thank you.
Yes, thank you so much. I can confirm that equally 8 days can be given to the applicant side to provide us with the information that you are not in possession of right now. However, this needs to be strictly respected. And again, as for the government side, this will be shared to the other side for any observations. So I thank both parties for their replies, and I turn to my fellow judges, those who ask questions, whether they wish to have further clarification on any point already asked. I see Judge Ni Raifeartaigh. Yes, please.
Very short, and it was overlooked, I think, but it should be non-controversial. The question that I did not write down, the status of witness statements who did not give evidence. What is the status at the trial, first of all, of a witness statement where the witness never gave oral evidence? And what is the status of a witness statement, not a report, not the HTS report? What is the status on appeal of a witness statement that came in after conviction but before the appeal judgment was handed down? Thank you.
I think this was a question for the government side. Am I correct? For both sides. So both sides are invited, if they so wish, to provide further clarifications if they have the answer ready on the spot.
Now? Yes.
We can hear you. Okay. Please go ahead.
Thank you very much. First of all, I would put on the record, because it has been distorted quite a number of times. There were 2 witness statements before the Çorum Assize Court which were given to judges by AB and YB. And there were 5 investigation statements in the file at the time the Çorum Assize Court took its decision. And we have mentioned the various names before. And we can show because the applicant responded to all those 5 statements that were given to police. So they were known to him and responded to him. Now, if you look at the minutes of the hearing which we submitted to you, you will see that in the hearing it is said that the whole case file was read to the applicant in open court. So he was basically confronted with the witness statements. The government, according to the Code of Criminal Procedure, submits that these witness statements can be taken into account by the court, and the applicant had the opportunity to respond to them and responded to them. If you look at his defense statements, he responds also to witness statements that are later on not mentioned by the court. With regard to the general practice in Turkey, once a case has been decided by the first instance court and it is then appealed on accounts of fact and law, new evidence will be added to the case file because the appeal court will decide the case on facts and law. And that is why the government submitted as the various documents the letter that were sent to the Samsung Regional Court showing that three more witness statements were added at that stage. And so they were before the Samsung Regional Court, and we submitted the documents where you can see the signature of the judges taking them into the file so that you see that the judges were aware of these statements when they decided on appeal.
Thank you so much. Would the applicant side wish to take the floor on this issue?
Yes. 1 minute, please.
Yes, I think we can hear you.
You can hear me? Okay. It's okay?
Yeah.
Yeah, okay. Yes. I also forgot one question I will shortly answer, but this one, our observation is that when there is new elements, indeed at the appeal court, it can be taken in account. On the condition it is contradictory. That, of course, the defendant can't defend himself against it. It is our strong conviction, we refer to the documents that we have made, that this new information was perhaps, we don't think so, but we will not discuss that too much, that it was not presented at the appeal stage to the applicant, to the defendant. So he had not a right. And I think there is no discussion that there was no material at the appeal stage that it should be submitted to the defendant. And I did not respond to your question about the numbers. We never said there were 200,000 BBTMs. We said there were 200,000 students. I refer to Annex 11, where we calculated based on the information of the Ministry of Education, where we made an extrapolation from Çorum, like our colleague did, knowing, of course, that Çorum is a small province. We made an extrapolation in 2 ways, and it's Annex 11. I did not respond. I apologize for that.
And briefly, so your first question regarding the oral statements and the fact that you need to contradict them as a key witness. So that is a general rule in Turkey, according to our understanding, that normally speaking, witnesses are heard in a confrontational manner in court. And this is confirmed by the government that this happened for 2 witnesses, A, B, and I, B. But what is also important in that regard is that our client, and that's also resorting from the minutes of the hearing before the Assize Court, is that he asked for a confrontation. He said, I want to challenge this discussion because I don't agree with their witness statements, and he never received that right, that possibility to challenge the witnesses. It is also the fact that in his procedures he also raised Article 6 of the Convention issues, and that notably concerned also that issue of the inability to challenge the witnesses. So I think.
Thank you so much. I see that Judge Đurović also would like a further clarification. Again, patience is. No red light yet?
I can also speak without.
You speak up, yeah.
Thank you, Mr. President. Just in line with the question in relation to the conditions, because we could see that one of the challenge of detention in the prison was that it was made to kind of have up to 500 prisoners, and at one moment, because of the coup d'etat and many arrested persons, it ended up having almost 2,000 people. My kind of follow-up, my clarification of my question would be, what has the Turkish state done to kind of secure equal level of, respect of human dignity and rights and privacy to the prisoners, despite the fact that the number that actually the prison itself got kind of really overcrowded up to 5 times to its original capacity? And that was also connected with the question of the water supply. Thank you.
This is specifically directed to the government, so it will only be the government responding to this.
And the government respectfully asked to submit the answer in writing to this.
This, of course, will be granted. Any further requests for clarifications? Not new questions, just clarifications? This does not appear to be the case. Thereby, we have come to the end of the hearing. I thank the parties for their submissions and answers to the court's questions. The court will now deliberate on the case, both on the admissibility and the merits. The judgment will be delivered later. The parties will be informed of the date of delivery. This concludes today's hearing, and I declare it closed.